Okay, good afternoon and welcome to this particular episode of the Gonna Cook 5 series webinar program. As billed, 5 top tips relating to financially troubled businesses. But hey guys, this is bonus day. You've logged in for bonus day today. You're going to get significantly more than 5 top tips as we go through this. We have an ambitious agenda. I'm going to try and cover each of these 5 subjects: the risks, the reality concerning people managing distressed companies, and then looking at rescuing companies, then rescuing businesses, and then flipping over to the other side of the fence in points of interest of those interested in buying a distressed business, and at the end we'll have a few words about the topical issue of multi-site retailer CVAs. That's a lot to get through. It's going to be a bit of a white-knuckle ride. So fasten your seatbelts and put your devices to one side. Starting then with management risks. This slide summarizes them. I'm going to talk a little bit about each of them. Breach of duty. Obviously, directors owe duties to the company they are directors of. Not just directors, it's those that perform the roles normally associated with directors, and also those who are shadow directors, which means that they, on their instructions, the actual directors become accustomed to act. All of those are in the sort of net of liability for breach of duty. The duties that are owed to the company are in most times owed for the benefit of shareholders. But there is judge-made law that tells us that when a company is on the verge of insolvency, the emphasis shifts and the duties are now owed for the benefit primarily of the creditors. That's not a direct duty to creditors. The duty is still owed to the company, but it's for the creditors as a whole benefit. Under breach of duty, I've mentioned those 3 subheadings. The point of doing so is that the facts that can support a claim for breach of duty also can give rise to other remedies. So under the Companies Act, there's a regime which entitles a company to claw back dividends paid to shareholders which were unlawful. If the directors of a company have caused it to make dividends pay dividends when it shouldn't have done, that can well be a breach of duty, giving rise to a remedy against them. I'm going to jump back to preference in a second. Transaction at undervalue, I mentioned here because it's similar. If a transaction at undervalue is giving something away or selling something for less than its proper value at certain times, and if that happens under the Insolvency Act, an administrator or liquidator of a company has a remedy to go against the recipient of that transaction. But the same facts, again, can support a claim for breach of duty against the director who caused it to happen. Preference is a slight oddity because a preference is where one creditor is put in a better position than it would have been in the event of an insolvency. And you can see the concept there. The preferences then can be clawed back against the recipient of the preference by a liquidator or administrator, because that's for the benefit of creditors as a whole. But then the question arises, well, is that a breach of duty? And the answer is probably no, because a breach of duty is a claim by the company for damages. And where a preference has occurred, there's no damage, because the company's balance sheet is exactly the same. An asset has been used to defray a liability. So the balance sheet's neutral as a consequence, and so it's hard to see how a preference claim could be pursued as a breach of the facts supporting a preference claim could be used to found a breach of duty claim. Moving swiftly on, because time is against us, breach of trust is often forgotten about. If a company is receiving anything, usually money like deposits, payments in advance for goods and services, on trust, and depends on its contractual arrangements with its customers whether or not a trust is created. Then if it does, and that trust is not respected by the directors, they can be liable themselves personally for breach of trust in an action brought against them by the beneficiaries of that trust. Very important for those companies in the financial services sector who receive client money. Deceit and misrepresentation is often overlooked occasionally. This when a company is in financial difficulty, it can be very tempting to try to preserve value in the company, to say things to counterparties to the effect to try to rally their support, to support the failing company. But stepping over the line and saying things which are known to be false and which induce that counterparty to act to its detriment can give rise to a personal claim by that counterparty for deceit or misrepresentation. Wrongful trading is these next two are wrongful trading and fraudulent trading are what I call the Insolvency Act offences. They're available to administrators and liquidators under the Insolvency Act. Wrongful trading is failing to take steps when the director knew or ought to have known that liquidation is inevitable. Now, this can be hard in reality for a liquidator to prove and indeed litigate, but bear in mind that these claims can now be fairly recent amendment to the rules. They now can be sold, and there are plenty of funders looking to buy potential litigation claims and make money out of them. So liquidators who may find it difficult to bring these claims may find it easier to cash in and sell to a litigation fund. Fraudulent trading is acting dishonestly, causing a company to trade in a dishonest fashion. There are cases which show that recklessly incurring credit when there's no reasonable prospect of meeting that credit can be fraudulent trading. Again, a risk where something is received in advance for goods and services to be performed by a company, a deposit or an advance payment. Receipt of that, when there's no reasonable prospect of actually performing the contract, could well amount to fraudulent trading. A device that's used to circumvent that, or at least to protect management in that situation, is to have a trust arrangement so that if the services aren't provided, the monies are ring-fenced and are paid back to the beneficiaries. But that will often require the consent of the company's bank, into whose accounts the advance payments would usually be paid, thus reducing the bank's exposure. So the bank may not be happy with that at all, so it's essential to get the bank's consent to such an arrangement. Finally, the final risk I'm going to mention today is disqualification. Every single company that goes into administration or liquidation the insolvency practitioner, the office holder, is required to file a report on directors' conduct with a special unit within the insolvency service, which reads through these reports and, where appropriate, or it considers appropriate, will seek a disqualification order. In reality, few and far between. They're looking for situations where there are large deficits to creditors, or where the directors involved are recidivists. In other words, they've had several insolvencies to their name. And to be slightly cynical about things, they're a results-driven part of government. They like to show successes, so they're possibly more likely to seek disqualification orders against those who are unlikely to oppose. So octogenarians, watch out. Right, so not just 5 top tips. Here we go. Straight away, we've got 9. We've dealt with some of these already. There's just 2 I'm going to specifically mention before moving on. The first is the second bubble there, which says that it's clear that if it's clear that only secured creditors have any real economic interests in the assets of the company, then cooperating with them is not a breach of duty. And this is something that was established in a case called Bluebrook a few years back, where it was suggested, where the opposite was suggested. But the emphasis here is that it has to be clear that the value breaks in the secured debt. If that's not the case, then directors have got to be very careful about who they cooperate with in a distressed situation. And the second one I wanted to just touch on is the next one on the to the right of that one. Granting an existing creditor security when it didn't have security before can be a transaction under value. I mention that because for many years the opposite was thought to be true, following a case called MC Bacon. And then a few years ago, a case called Spread Trustees demonstrated that actually, in certain circumstances, it can amount to a transaction under value, with all the consequences for breach of duty that I, for example, that I mentioned earlier. All right, we need to move on. I'm now going to talk about tips in relation to rescuing, first of all, companies and then businesses. First of all, let's just think about the distinction between that. Clearly, if a company is rescued, all of its creditors need to be satisfied with whatever is proposed to happen. Whereas in a business rescue, as we'll see, that's not the case. But now I'm just looking at, in both cases, we can say that it's not, the fundamental question is, is there something worth rescuing at all? Is there a viable business worth rescuing? Far too many times, and sadly, we've seen some of the procedures I'm about to mention used with regard to a company that fails again shortly after, within months or not many years after some sort of rescue has occurred. So it's really not worth doing this unless the business essentially is viable. Right? What happens in these situations? We're all human beings. We all like curves. There you go on the right-hand side of the screen. You've got a crisis curve. Very simple schematic which intends to show that as performance deteriorates over time, a crisis accelerates quickly. And time is of the essence here. This is the whole point. As a business is in difficulty, the time it takes to rescue it can be a barrier. Company rescue, as we'll see, takes more time than business rescue. On the left of the slide, you've got the various things that can happen. A consensual restructuring is where there is simply agreement between the company and its creditors without any use of any tool or procedure which enables it to carry on operating. Where we can't get a consensual restructuring, we have some tools. We have, for corporate rescue, we have a scheme of arrangement or a CVA. If we can't achieve a corporate rescue and are looking for a business rescue, which tends to mean we're halfway down that crisis curve or beyond, then the tools of administration can come to our aid. If we're at the bottom of that curve and value is no longer preservable at all, the best we can do is put it into liquidation, which in the trade is known as a burial. This is a busy slide. If we're doing we're talking about company rescue now. As I said, getting agreement with creditors. There are two kinds. Sometimes they're combined. There's a financial restructuring or operational restructuring. For a financial restructuring, as you can see, there's a load of things that need to be agreed between the lenders and shareholders. So all those with an investment interest, if you like, will have to agree. Normally, often a standstill to stop them enforcing their rights. I'm not going to run through that list. You can look at that later in your leisure. But just suffice to say, a lot of things to be agreed and sorted out, all based upon information which they need to obtain from the company in order to make valuable or good judgmental decisions. On the operational side, we're talking about what the company actually does. And if we need to restructure some of those relationships, we need to think about operational restructuring. So that is, are we talking about impairing the rights of certain suppliers to the company's landlords, for example, in the CVAs? Consultation with employees, are we going to be losing some of the workforce? We need to renegotiate some commercial contracts or seek amended regulatory permissions, that sort of thing. And very much looking at if we've got a group of company on our hands, we need to look very closely at the relationships between each member of the group with the others. So those are what's entailed. It takes time to do a restructuring which achieves a company rescue. I'm not going to go through this slide either, but these are just the differences between schemes of arrangement and CVAs. Suffice it to say for present purposes that a scheme of arrangement requires 2 applications to the court and entails the division of creditors and shareholders into separate classes, defined by reference to whether they are of the sort that can reasonably be expected to vote in the same class. 75% majorities in value and number, in each class are required to be approved, and then the matter goes back to court for final approval, and it has to be fair. The court will judge that. The CVA is much simpler. There's no classes, just 2 or 2, shareholders as a whole and creditors as a whole. And there's no court involvement unless somebody challenges it by going to court and claiming unfair prejudice or material irregularity. In essence, those are the differences between the two. And in general terms, a scheme is used in financial restructurings, whereas a CVA is used in operational restructurings. Here's your top tips from that little part of the presentation. The first of which is, as I mentioned, crisis curve, get the professionals engaged early. I know that sounds self-serving, but it's true. More chance of preserving value and rescuing the company if you do, less chance if you don't. You've got to be thinking about how you can achieve credibility with your stakeholders, absolutely essential. And another reason for bringing in professionals, because they will be your interface with your major stakeholders. As I said, is the business viable? Is the problem identified, and realistically, is it fixable? And communicate with those key stakeholders. Nobody likes surprises. You will need them to be on side for this business to continue in some shape or form or another. Communication is key. Swiftly moving on, rescuing the business. Okay, so we're now in a situation where, for whatever reason, we're too late down the crisis curve, or the tools of a non-consensual rescue, CVAs and schemes, are far too lengthy to action or expensive. So now we're thinking only about rescuing the business. First question, rescue the business is simply selling the assets and the business to a third party and leaving the liabilities behind in the old shell. Can the directors of a company do that? Well, the answer is yes, they can. There's nothing legally to stop them doing that. But is it sensible? How do they establish the price for which the assets are being sold? Professional valuations are one thing, but they can be challenged by some subsequent professional valuation that says, no, that one was crap. The only way really to test value is to test the market. And how do you do that when you're trading in a competitive environment? In any event, if there's a secured creditor with a fixed charge over assets, it will need to, or floating charge, will need the consent of that creditor to release the assets that you're intending to sell. Far better than taking the risks associated with an asset and business sale to get an administrator to do it for you. These guys are well accustomed to that sort of practice. They know how to meet the points I put on the slide. What will tend to happen is that, as I mentioned earlier, no one likes surprises. Speak to the secured creditor if there's one. If there's a secured creditor, what will happen is that they will need to know what the best thing to do is. They will require the company to engage an insolvency practitioner in the role of an investigative accountant, not at this point being appointed administrator or anything else, but simply engaged by the company as a professional. And his role will be to produce what we call an IBR, one of the trade's most obvious misnomers. IBR stands for Independent Business Report. It's not really independent at all. It's for the benefit, essentially, of the secured creditor, who will then make decisions as to what to do. While that is going on, there will normally be a degree of what we call in the trade again contingency planning. If there is going to be an administration, if that is and a business sale, then that needs careful planning. It's not prudent to simply go into administration, as you'll see in a minute, without any strategic plan. But that's when a plan is developed, and that's at that stage. That's where we get to our next subject, really, which is pre-packed administrations. What is a pre-pack? Why do we have this? I mean, all it really is an accelerated sale by an administrator An ordinary administration, should we say, a non-pre-packed one, is one where the administrator gets appointed. There's no real plan apart from trying to find a buyer. The administrator will try to keep the company trading to preserve its value, its going concern value, and then sell the assets when he finds the right to the best bidder. But that has difficulties. Here they are. Although in administration there is a moratorium preventing creditors enforcing their rights, key employees and customers are liable to drift away. They will say to the administrator, how can you be certain this company will be here tomorrow and doing what it's doing, giving me a job or supplying the goods I want to order? And he'll say, I don't know. I'm trying to find a buyer. I hope I will. I can't be sure. Well, if you were that third party, what would you do? If you had an alternative source of what you want, i.e. employment or the goods you want to buy, you might well go elsewhere. So value will drift. Regulatory permissions often are suspended in the event of an administration. Third parties with rights to terminate their contracts on the happening of an insolvency event may choose to exercise that option. Administration does not prevent that. So licensors of essential software, for example. Meanwhile, if the company is still trading, it is probably still loss-making as it was before administration. Who's funding that loss? Usually the bank, but then the bank prepared to do that indefinitely until or unless a buyer is found. And the brand is obviously tainted by the fact that it's gone into an administration. So for all these reasons, it's perfectly sensible to have what we call a pre-pack. In that situation, the buyer of the business and assets is identified, the deal is negotiated with the administrator in the wings, or to be in the wings, and is executed immediately upon his appointment. This requires the directors to work very closely with the administrator to be over the whole process of finding buyers and negotiating a sale contract. And in that situation, the directors are in a very difficult situation because they know that the company at some point in the future is going to go into administration. So how do you deal? It comes back to the points I mentioned at the beginning of this presentation about management risk. They have to be very careful about what they say to people, and very careful about what deposits they accept, and so on and so forth. We call this the twilight zone, and it's an area of high risk. And again, best advised management will take very close advice. Top tips. Oh, there it is again. You're seeing a theme here. Get the professionals engaged early. Ensure the secured creditor is on board. Again, to release the assets, you need his or her consent, its consent. In that twilight zone, the general rule is only make business critical payments that are absolutely necessary to preserve the value of the business. And if there's any doubt about the decisions that management are making in this situation, fully minute them. So there's a paper trail so that someone coming in later on can see exactly what they were faced with and why they made the decision that they made. Invaluable. Right. As I mentioned at the outset, we probably will go slightly over time, so bear with me if you will. If you don't want to, then that's fine. You can get a copy of these slides and indeed of the recording of this, of what I'm saying, after the event. Now it's time to flip the coin and look at the position from the perspective of a buyer of a distressed business. Two choices: share deal or asset deal. Do I buy the shares of the company or do I buy the assets? The slide lists the important points in relation to a share deal. First of all, note that an incoming investor, incoming shareholder might want to, often does actually, agree to put new money in, put his investment in, conditionally upon the approval of a scheme or CVA. He's not going to put his money into a company without the scheme or the CVA having the effect of tidying up its balance sheet. So the scheme or the CVA will have the effect of, whatever it has, it'll basically put the company back into a solvent position again. In that situation, the money will come in. One way of doing it. Again, though, secured creditor consent is going to be necessary to a share deal. Watch out for companies often have contractual provisions with their counterparties that give a right to terminate in the event of a change of control, and of course that could well be what's happening here. So the due diligence conducted by an incoming shareholder needs to focus on that and make sure that there's no real risk to the business he's thinking to invest in. And the problem with a share deal, though, is that typically they will include a very complicated series of disclosures and warranties. A share deal contract is a lot longer and more complicated and takes longer to negotiate than than an asset deal contract. The alternative is to do the asset deal, is to buy the business from a company in a pre-packed or other administration process. Important points to note. In this situation, there are no warranties. The administrator will not give a warranty at all about the assets that you are buying. No, not even as to title. It's completely buyer beware. Worse still, the administrator will require a whole series of indemnities to protect him from risk. They're quite normal. Most of them are within the control of the buyer to minimize liability under, but you will be faced with those. And time will be short. There's no time to try and negotiate these out. Counterparties can't be forced to trade with the buyer. You're buying assets. That's all you're buying. You're leaving liabilities behind. The contract can say that contracts are being assigned. The reality is, at law, that without the consent of the counterparty, that really is fairly meaningless. So the buyer has no certainty that the company's customers or suppliers who had whatever contractual terms with the old company will replicate those with NewCo. So you have to be confident that when you think those are important, then you can replicate them in the new vehicle. If the company relies upon regulatory permissions, they are frequently not transferable at all. So they can't sell them to you. You have to go and get new ones and be prepared to have them on day one after the deal is completed to have a seamless as possible trading situation. Having said liabilities don't transfer, the one set of liabilities that does are employees. That's because of something called the Transfer of Undertaking Protection of Employment Regulations, or 2P for short, which in summary ensures that anyone who is an employee of an economic entity, anyone who is associated with that economic entity, will transfer to the transferee of that entity. There are all sorts of complexities around that, which I'm not going to go into today, but that's basically what happens. Even for an asset deal, you have to get the consent of an administrator can sell assets subject to security as long as they're subject to a floating charge. For a fixed charge, he needs the consent of the fixed charge holder or order of the court. But the advantage, or one advantage, of a purchaser of assets on a deal from a company in administration is there's no risk of the transaction being challenged under Section 238 of the Insolvency Act, which is transactions under value, because that gives rise to a remedy to challenge transactions if they're entered into in the period prior to insolvency. This, by definition, happens immediately after or shortly after the process begins. The next two slides are really for you to consider at your leisure. I have put them here to just demonstrate a point I made a little earlier, that rather oddly, there can be no real difference in terms of outcome as to whether it's a shared deal, i.e. a company survives because someone comes in and acquires the shares or puts more money in. So a company survival, and a business survival where the assets actually move to a third-party company because in either case you will end up with a company where the shareholder makeup may well have been substantially changed, where the same creditor who had security over the assets still has security over the same assets, where the management may or may not have been substantially changed, and where some, but maybe not all, unsecured creditors have been impaired to some extent. Both sets of procedures can achieve precisely the same result. There's the other slide, which shows that it's a little bit complicated, but it makes sense if you have the time to consider it. Top tips from that part of the presentation. Oh, look, there it is again. Get the professionals engaged early. You know it makes sense now. Whether you're buying shares or assets, you have to plan your due diligence accordingly. but for slightly different reasons, as I've mentioned. You must ensure in both situations that key counterparties are on board, otherwise you will have a viable business going forward. And because of that crisis curve, time is of the essence. Be prepared to transact quickly. I have so many stories I could tell you of clients who've come into this situation thinking they can buy a distressed business and then haven't been equipped to transact quickly, and they fail. And so does the business. Finally, I'm now officially over time, so I'm only going to spend 2 or 3 minutes on this. The topical prospect, or not prospect, the topical thing of multi-site retail CVAs. What are we talking about here? We're talking about situations where there's a company that trades from a large number of rented premises. And that company puts a proposal, CVA, to its creditors and says, right, vote in favour of this. You'll recall we need 75% in value majority to make it stick. And the proposal says the landlords are going to be impaired in some shape or form. Some landlords are going to have to accept monthly rather than quarterly rent. Some landlords are going to have to accept less rent. Some landlords are going to have to find their premises, have their leases back. But by the way, they can't sue us for the damages that are occasioned by that. Because they're the ones to blame for the company's misfortunes. If we could get all that right, sort the leases out, then we can be viable and profitable for the benefit of everybody else. Nobody else is going to be impaired at all. That's typically what these CVAs say. And they also have a little device in them to determine how you calculate the voting rights of landlords. The voting rights, so people can vote with regard to the value of their debt. But how do you ascertain that? Whether the rent, say, is up to date, or even if it's in arrears, but there's 20 years to run? Well, the answer is that you have to look at the particular premises and location and take a view as to what the landlord's likely loss is, and that will be the landlord's claim. But that's very cumbersome, and every single property will be different, have different dynamics. So what the CVAs try to do is impose upon the landlords a one-size-fits-all method for calculating their voting rights. Are these challengeable? You may have seen the press a couple of times recently. There's been talk of challenges. There was one, I forget which company, if we come back to me in a moment, recently that was challenged, and then the challenge was withdrawn. I'll come back to that in a minute. But they are challengeable, but only on grounds of unfair prejudice or material irregularity. The problem at the moment is that we don't really know what amounts to unfair prejudice. There have been cases on this, but it's really a very underdeveloped area of law. So are those features I've described unfairly prejudicial to any particular landlord who's complaining about them? Well, so we don't really know. On the face of it, to me, it sounds very unfairly prejudiced, because you have a whole bunch of people who are not going to be impaired at all voting to impair a very small number. And for reasons that are obscure. Why is it the landlord's fault that the company isn't viable? What about the money that the directors have been paying themselves in salary? What about the interest that's been paid to banks? What about etc.? We could go on. So I'm not entirely convinced that these things are beyond challenge. Certainly the point about one-size-fits-all to voting rights could well be regarded as a material irregularity in the process. But as we've seen, these things are rarely challenged, and when they are, they seem to fall away. Why is that? Well, a number of answers, actually. The first is that don't be fooled by what meets the eye. When you hear that 95 or 98 or whatever it is % of all creditors, including landlords, approved a CVA, it's not surprising, because behind the scenes, before the damn thing was even put to creditors as a whole, there have been negotiations with all the landlords. And the landlords have been told, you've got two choices. Either we're going to go bust and you have to find a new tenant, or here's a deal, which is you either you get this, that, or whatever. And eventually those landlords agree to whatever is proposed, or they negotiate to the terms they want that can be agreed. So in fact, it's not surprising that they will agree, because they've all been pre-negotiated. And in that sense, of course, the landlords are taking the view that the alternative, which would be a pre-packed insolvency where they may or may not the leases may or may not be assigned to a buyer, are less attractive than whatever the CVA is proposing. Another point is that if one does challenge the CVA and succeeds, it is unfairly prejudicial, court strikes it out, costs in your favour, Mr. Applicant, jolly good. When you come to enforce that costs order, you find that the company has now gone into administration. So it's unenforceable, irrecoverable. So it's an expensive process. And of course, as I mentioned, there's the legal uncertainty of outcome. So these are all kind of reasons why it's difficult to challenge. I've got some top tips for you, though, on why the challenges don't really happen very often, and why it's difficult. But top tips. There it is again. Get the professionals engaged early. Absolutely. These CVAs are complicated. The art of getting a deal for a creditor who's adversely affected by one is to understand what's going on. And the only way to do that is to study it and to think about it. You need to be thinking about, well, okay, so my client is suffering here, but who's benefiting? And is the juxtaposition of interests fair? And if not, how can we exploit the sensitivities? If you've got a shareholder coming in conditional upon the CVA being approved, then that investor has got a lot to gain by the CVA being approved. It's a clean way of acquiring what he wants. The alternative is to fund a new co to buy the assets in a pre-pack. That's far more expensive from that investor's point of view than getting a CVA approved. So if you can force a situation where you challenge them on that, there's money, you can squeeze money out. You can't do it by getting a side deal. Okay, do a deal with us. Yeah, we'll come quietly, and then we'll take a surrender. We'll give you a surrender. You pay us a lump sum. Because if you do that before the CVA goes to creditors, you have to disclose it. Otherwise, it's automatically a material irregularity and liable to be struck down. That's no good. What you have to do is let the CVA go through and then challenge, and then settle the challenge, which might explain why we've seen a few challenges reported in the press that then go away, because what's happened is that side deal has been done after the event. All right, those are my top tips on everything that I've discussed today. I've gone slightly over time. I do apologise for that, but I did warn you. If anything is unclear, if anything requires further explanation, I'd be delighted to explain. Those are my contact details. Thank you so much for listening.